Welcome to the About podcast. Here we explore your financial health in simple and easy to understand ways.
Well, hello, everybody, and welcome back to the About podcast. This is Jeremy Scott, one of your hosts here, and, of course, joined ably as ever by Roy Hookie. Roy, how you doing?
Hey, I'm doing well, buddy. How you doing?
I'm doing really good. I'm very excited for today.
You're always super excited.
I'm always super excited. Because anytime we have a guest, it's good times. Anytime we have a guest that's deeply knowledgeable, even better times. And today we get to do a little pop culture, which is not our normal bread and butter here on the About podcast, but I think we can do it.
I think people are going to learn from it for sure.
Oh, yeah. Oh, there'll be this is edutainment right here.
On the edge.
Edutainment. And because today we are welcoming Skyler Budman, attorney at law from Budman Law. Skyler, how you doing?
I'm doing well. Thanks.
Yeah, nice. And you're coming to talk us about something that on the surface might sound maybe not the most exciting, estate planning, something we've covered before, but we're going to spice it up with celebrity estate planning.
Yeah, exactly. It's, in my opinion, estate planning is one of the most interesting things we can discuss, and I think Roy might agree. But when we add the celebrity component, it'll hit a bit closer to home, I think.
So Skyler, I've known since he was just a little fella. So probably about 17 years ago is when I met your father, by the way. And I've known of you for sure because your dad just brags on you all the time. But you've been practicing law with your father, which is pretty awesome. So you're both attorneys, and Brian Budman was also on the podcast. Check that out, Essentials of Estate Planning, our episode.
Absolutely. Shout out to that episode.
Very good episode. But today was really about, hey, we run into these scenarios where let's learn from people who make mistakes.
Right.
And, we've had some people actually in our lives, Jeremy and I, who have passed away young. And, we want to make sure that people, we're going to do some fun stuff here, but we're also going to learn from that and figure out, what is the basics that we need to make sure we have covered by the end of this conversation today. So I'm really excited to kind of talk about it in a fun way, learn from some celebrity situations, and the pro himself over here, Skyler, is going to walk us through that. So I'm very excited about this, Skyler. Thanks for being on the show.
I love it because this gives us a chance to talk about basically a real world case study with real people that are not, but that are celebrities. So we all kind of know who they are and everything else. So yeah, Skyler, welcome.
Yeah, thanks for having me.
Here's my first question for you.
Sure.
How does this stuff get out in the public?
Oh, yeah, well, that's a good question.
I actually was wondering that when and I'm like, I'm going to save that question. I'm like, how do we even know?
Right. Let's start there, buddy.
Yeah, well, the simple answer is that the process is public. So when somebody passes away, depending on how their estate is designed, it goes through a public process. Mm-hmm. Any court proceeding is public. So most of these cases that are being discussed, they're cases of estate planning failures, and then the heirs of the decedent are trying to rectify those errors, and they're going through the court system in order to do so. And all of that's public knowledge. I'm sure there are tons of examples of people in the community who have made mistakes with their own estate planning, but of course, people don't spend a lot of time digging into that unless, of course, they know somebody who's passed away. So it's all public information.
But to be clear,
yes,
the legal process of a probate is public.
100%.
But there's ways you can design it so it's not public.
There are ways you can design it so that it's not public, but even if you design it through those ways, like using a trust, if the trust doesn't cover everything that it needs to cover, then people usually take the trust to court, and when they do that, it becomes public.
Got it.
Yeah.
Got it. So you can do a lot. Anybody can sue for anything. It could become public depending on the situation and how it was designed and if they had everything buttoned up or not.
Yeah. No, exactly. Yeah.
So we're going to talk about that stuff then, huh? That's how this stuff got out.
Absolutely.
It wasn't buttoned up.
It wasn't buttoned up. Yep.
It's really interesting to see how much privacy kind of goes away when you die. Right, how much stuff becomes public. I've gone through that. I've worked with people at the church and who discovered that, and they're like, "Oh," and I'm like, "Yeah, it's all out there." Most of the time, just nobody's looking, right? Because why are you going to look up the probate proceedings for your random neighbor? You wouldn't. But a celebrity, people are going to start digging. They're going to find every little piece of Freedom of Information Act information they can get their hands on.
No, it can be popular in the community too. You guys are in a smaller community. I'm coming out of Denver, and in Denver, when somebody passes away, their local community might pay attention. But in smaller towns, we often see that someone passes away and somebody wants to know who they supported, where their assets are going, who their beneficiaries were, charities that they supported. People are curious. So
I think the right word would be nosy.
okay, well.
All right. Well, let's get our gossip on. And where do you want to start?
Present us
Skyler?
with some info.
All right. Well, I thought we'd start with Kobe Bryant because that's kind
Everybody
of
knows Kobe.
Everyone knows Kobe. It's a current case, and interestingly enough, in the case of Kobe Bryant, his estate plan was much like him. So it wasn't the case that Kobe didn't have things in place. It was the opposite. Kobe did have a lot in place, but there was a major oversight in his estate plan. So I could kind of, you want me to introduce Kobe Bryant, or do you want me to go into his estate plan?
Well, hold on. I think the one thing that's interesting about that is that he did have something in place, and given that, one, he was as young as he was, and two, he was as sudden as he was.
Sure.
So obviously somebody, him or somebody who helps him out, was planning ahead. So first, shout out, you're never too young to work on your estate plan. That's lesson number one. I mean, at least he had something, because that was obviously very unexpected and very sudden. So I'm a little surprised there was anything in place, because if I'm Kobe Bryant on top of the world the way that he was, he probably thinks nothing's going to hurt me. I'm gonna live forever. And I'm like, no.
No, it's true, and that's a big theme that we see with celebrities. Yeah. I mean, they get to a point where they're very successful, and I think they think, well, I'm kind of in a position where I don't have to worry about what's going to happen when I'm no longer around.
So I have no idea what you're about to share, but number one, props to Kobe for having anything in place, given where he was in life.
No, of course. Kobe had a lot in place. Okay. He had a complex trust structure. From what I've been able to glean from the records that are available to us, he didn't just engage in estate planning, but he likely engaged in tax planning as well. Huh? Now, what Kobe did was he provided for his children in his estate plan, as a lot of people do. But between the time that he had last updated his estate plan and his passing, he had his youngest daughter, Capri, and she was not included in the estate plan. She wasn't mentioned by name. And interestingly enough, she also wasn't even referenced. So his wife, Vanessa, she actually had to go to court, petition the court to include Capri and show that the intent of the decedent, the intent of the grantor, the creator of the trust, Kobe Bryant, was to have his daughter included. And so, it wasn't perfect.
Isn't there typical? I mean, don't you typically add language? It's like if any other errors exist, then the same
future
thing
children
occurs,
unnamed
kind
or
of thing?
No, that's a great point. So what I found interesting about that is exactly what you're saying. When we draft an estate plan, and there are certain circumstances where you wouldn't mention afterborn children, because maybe the people who are creating the trust are older. So you think the likelihood of them having afterborn children, additional descendants, it's not very likely. But in the case of Kobe Bryant, he wasn't that old of an individual.
Yeah, or anybody
so
that's
you would have
that
thought,
young, right?
Yeah, so typically, even in an estate plan where you specifically mention children, you also include a provision where you say, and any other descendants shall be provided for in the same manner as, say, my other descendants. Yeah. So it's kind of interesting.
That language wasn't there.
That language wasn't there. And it's very common to include that language, but it's interesting because a man like Kobe Bryant is somebody of means, and you would imagine that he had access to some of the best estate planning attorneys that he could have had access to. And despite that, his wife was still embroiled in a court battle trying to deal with ensuring that their youngest child, she was 1 at the time, was provided for in the estate plan. So, he was on top of things, but and very likely this wasn't an oversight on Kobe's part. It was an oversight on part of his attorneys and something that he wouldn't have seen on his own, right?
Yeah, I mean, you depend at that level of wealth. I'm sure you depend on your professionals around you to make sure that's covered. But also sometimes I wonder, and I have seen it play out where people of immense wealth think they want something and nobody challenges them.
Yeah.
Mm-hmm. And he's like, yeah, name my kids. And that's all I want. Yeah. Okay, we named your kids. You had another kid. Didn't think about that, did you?
Right.
And then it's not in the thing. So then because the child wasn't in it, the wife took the estate to court to
so essentially
get the youngest child included. And that's what made it kind of public.
Well, really what it is you're asking the court to interpret the document. So when a document's created, and this can happen this could happen for reasons that have nothing to do with beneficiaries being left out. It could also happen due to something like an ambiguity. But in certain states and in certain trust plans, you have to go to a judge and ask that judge to interpret the document and give you permission to have the document say or be carried out in a manner in which you believe the creator wanted the document to be carried out. So that was the situation here. And that can happen too if there's a typo in a document, if there's a provision that's omitted and it's very obvious that that provision should have been included. This is a little bit more unique, and this is something where a child was actually left out. So,
Wow.
So you got to keep those things updated.
you have to keep them updated, and that's usually life events, right?
Yeah, I know that when first time I ever had a will or anything like that was right after my son was born, and then we didn't touch it, and even after my daughter was born, and we're like,
For 15 years.
yeah, we didn't touch it for a long time until I'm like, oh, but I think there was some language in there that said eventual, if there's any additional children. So
Yeah.
interesting. Okay.
So any other fun facts around that situation?
Well, there was
Kobe?
another controversy that actually arose in the Kobe case where Kobe's mother-in-law had assisted with the children. And so she actually challenged the estate as well because she felt that she was due back pay for childcare that she didn't receive during the years that she was providing for childcare for the kids. So there was a controversy that the estate was embroiled in on account of that, and that's maybe a different legal lesson, but still something that came out of this.
So is it clear on how the estate was actually transitioned? Did it go to the spouse at the time, the part to the kids, or how is that clear?
It's not 100% clear.
So
it
not
did.
all of
I
it's
mean,
public.
his wife was provided for, but what I imagine happened because of how significant his estate was, certain assets went to the children, and certain assets were divided among his wife and his children, or at least his children were included as contingent beneficiaries after his wife.
And maybe his parents or stuff like that.
Sure.
Which we're not clear on.
No, we're not
Got
clear
it.
on that.
So the mother-in-law, which is his wife's mother,
Yep.
decide like, no, I should get a little piece here and get taken care
Yeah.
of.
No, exactly right.
And anybody can challenge for any reason. Did she win?
Well, there was a private settlement. So we just know the details of the challenge, but we don't know exactly what happened. But let's just say, based on the facts that came out during the trial or during the proceedings before the trial, we found out that Kobe and his wife had provided for the mother-in-law pretty significantly. She had a vehicle, she had a home that he was paying for, and so her interpretation of the situation was that none of that constituted compensation. So.
Oh, interesting. So, and the one had there not been a kind of a settlement, then eventually that would have ended up in front of a judge.
Oh yeah, of course.
in a trial. Like,
And it
but-
would be a public.
And if this go, I mean, if somebody says it's like, no, I'm taking it all the way, so that is in front of a judge. Like, can these things end in front of a jury, or are they mostly settled by judges?
Typically not. Typically
Okay.
they're not handled in jury trials.
Right.
Typically it's what's known as a bench trial. You just have the judge proceeding over it. But depending on the nature, because this is business related as well, right? I mean, she's claiming that she was essentially an employee who was uncompensated. So, and there were no contracts.
And that opens up a can of worms too, because then you have all the employer-employee stuff that
Right.
wasn't accounted for. either.
I know a lot of grandmas who watch a lot of grandkids.
They may have a claim.
A lot in my church, and I don't think they're coming after the estate.
So you
I
need to
think
have
you're
them
doing it
sign
because
a-
they're a good grandma.
Sign a document like a prenup. This is a pre-care document
exactly.
where you're not going to get any.
Oh,
kind of
I didn't even think
compensation.
about it. You know, oh man, jeez, because this happens all the time in
Does.
families.
Well, I think the really interesting thing that people need to understand is, when you think you're doing planning, you think you're stopping people from doing something, and the reality is anybody can make a claim for any reason realistically.
Right.
It doesn't mean they're going to win, but it just means that anybody can make a claim for any reason and try and finagle some money.
So the youngest daughter, they worked that out. She was able to.
Yeah, ultimately she was included. It was clear to the judge that the intention of the decedent was to include his entire family.
Okay.
But that doesn't come obviously without cost, right? Going to court and dealing with that and dealing with anguish while you're already dealing with other anguish is usually worse.
Is there any clarity, just because we're dealing with immense wealth for someone, is there any clarity on how they deal with their estate taxes?
Is there clarity?
Yeah.
Well, there's strategies. There's
Well, no,
different
but I'm
strategies.
just in specifically Kobe's situation. Was there any kind of clarity of how they handled that, or is that all kind of just private behind the scenes? Couldn't find out.
No, it's private behind the scenes. So in a lot of these cases, only the parts of the trust that really need to be interpreted by the court are the parts of the trust that are going to be made public. But then beyond that, the way that the trust is funded or the other assets of the estate, the other trusts of the estate, those are not going to be made public just because they're immaterial in these cases. So no, in terms of how he planned for his estate taxes, or even if he did plan for his estate taxes, that's not clear based on the documentation that we have publicly available.
In what state was this in?
California.
Oh boy,
Yeah.
That's like the worst state to die
Yeah,
in.
exactly. Bigger issues there. Than
Yeah.
anywhere else.
I'll note that for myself, right?
Well, it's actually interesting because the probate process there is very lengthy, and this is why it's a very difficult state to pass away in. And I have clients right now dealing with this situation with some inheritance money that it takes a long time for it to go through the process.
Gotcha.
So that's why it's a horrible state to die in.
All right, so that's Kobe. Learn to make sure you keep those stuff updated. That's our lesson from Kobe.
Yeah, keep things up to date, right?
Keep it
Having
up to
children necessitates a conversation with somebody in
events.
your life, your
Well,
advisors.
even adding that, maybe it's ambiguous language to you now because you're like, I'm not having another kid. Well, just add the language because if you ever did, you're covered.
Right.
No, of course.
Right? Like add the what if scenarios.
Right.
If it's not going to harm anything, why not add the language?
No, it's a good point because recently I had a conversation with somebody where they went through an entire estate planning document that I prepared, and they found language in there, and they said, "Look, it doesn't apply to me. I don't have agricultural land. I don't have a 401k. I don't have an IRA, but there's language in this document that specifically deals with those things. I don't have mineral rights, but the point is that you're not planning necessarily based on everything that they have at that moment.
Right.
You're planning based on the contingencies that could come up. So it's not a bad thing to have a lengthy document because you'd rather be overcovered than undercovered.
Now, I will tell you a funny situation where I had a client that was reading their documents, and they were like 55, 60 years old, something like that. And it had a provision there about in the event that she became pregnant. She was like, I don't think I need that provision at this point in my life.
No, it's true. That's exactly what happens.
But, it was language that was added for a reason. And, that attorney could have been a little bit more specific, but they just left it in, because it was a broad spectrum situation.
Well, and I mean, you never know. Life goals change. You might literally buy the farm someday, and then you'll glad you have your agricultural land provision.
Well, that's a provision you definitely have.
Yeah.
Right?
Yeah, that could happen. And it happens in Colorado.
And you don't know, what if you got left in inheritance?
Right. 100%.
I mean, I've had clients my uncle left me something in Vermont, and it's a piece of land in the woods kind of thing.
Right.
So who knows?
All right. So what do we got up on deck now?
All right, so we're going to take a big change here. We're going to go from somebody who did some planning to somebody who did no planning.
No planning.
So,
No good.
have you ever heard of the artist Prince?
Prince did no planning.
You mean the artist formerly known as the artist Prince?
Did he die formerly known, or did he die Prince?
I don't actually know because he went back, I think.
Well, then he was the artist for a while. It was Prince.
And wasn't it all about
and then it
messing
was
with the contract he'd signed with
he
the
was
label?
messing with his record label.
Yeah,
Yeah,
he wanted to own his own music.
Yeah.
Which is
Crazy.
interesting, right? But it's interesting because at that time it was novel. It wasn't something that artists were regularly doing. A lot of them were beholden to the labels.
He was fighting the machine.
He was fighting the machine. He was planning, obviously, to make sure that he had wealth coming in and somebody else wasn't controlling that. But then when it came to his estate plan, he didn't do anything.
I'll never die.
I think we got to shout out Taylor Swift on that one because she's the one who made that all big news. She
Yeah.
she bought it all back. She got the rights back to all her music.
Yeah,
So-
I had a note here. The reason he had changed his name to a symbol was to fight Warner Brothers.
Yeah.
So he's going up against Warner, which is at the time, it's a
hefty.
big machine.
Yeah, that was big
one.
times.
Yeah. So,
All right, so Prince, no
So,
planning.
First question.
yes.
There's a name for when you die without a will or any planning at all. What's that called?
Good question. It's called dying intestate.
Intestate.
Yeah. So when you die without any estate plan, you die intestate.
Okay, then what happens? Because Prince obviously went through it. His estate went through it.
Yes. So good news, and good news for your listeners. If you don't have an estate plan, you actually do have an estate plan. The state has created an estate plan for everybody.
The state that you reside in.
Yeah. So the state where you're domiciled, where you say that you're from.
Yeah.
That's those are the laws that'll govern, the intestacy laws that will govern.
Was that Minnesota for him?
Minnesota for him. Yeah. Wow.
look
that was
at
good.
I knew that. I had no idea.
Yeah. He's big.
But,
Minnesota's very proud of Prince. So.
I had no idea. I mean, I would have thought it would have been another California case,
Yeah,
but I saw
a
Minnesota
warm
as
state.
well. So, but in Colorado, I mean, the intestacy laws, they're very similar across the United States. But in Colorado, the way that it works is you go down the family tree and then you go up and out and you keep going down. So
I
it's
never knew that.
it's down to the descendants. If no descendants, it goes up to the parents and it goes to their descendants, then their descendants, and it could continue going up and out. So, obviously if the parents had no other kids, it would technically go back up and out. Now, if there's nobody to take, at a certain point, the state says, this is ridiculous. We're not engaging in the exercise of trying to track somebody down. And eventually, the state could take it. The state could become the inheritor. But the common misconception that people have is that if I don't have an estate plan, I don't want everything I have going to the state. The good news is that if you have a wife, if you have kids, if you have parents,
Heirs
if you have
of any kind,
siblings,
really.
Well,
it's not going to the state.
And it's spouse first.
Spouse is first-ish.
Ish.
Depends on if you have your children. All of your children are with the same spouse.
Correct.
In which case it could change. So there's calculations, and then the tables are based on how long you've been with the spouse. If you've been married for a day versus if you've been married for 20 years, right? So
And if it doesn't matter if the children are minors or not.
no, it doesn't matter if the children are minors.
Oh, okay.
It just matters which relationship the children are from.
Yeah.
That's the biggest consideration.
That's very interesting. I didn't know it went down and then up and out. Because I always thought it would go to your siblings before it go to your parents. Just,
Yeah, no, it works.
generations.
It works up. It works
Yeah.
back up, and then it
Okay.
goes back out. Yeah. So in a lot of cases, the parents are not there, but we still consider the parents and the parents' descendants when we're figuring out where the estate's supposed to go.
Interesting.
Well, when the state, if there's nobody to receive it, it essentially gets escheated to the state, right?
Exactly.
But then they have to hold it for a period before they do anything with it, don't they?
Yeah, they hold it for a period, and that period is usually to see if somebody's going to step forward. I mean, the process for an estate or the sum of the estate to end up actually going into the coffers of the state where you die, it's not immediate.
It's a long process.
It's a long process. It's very unlikely to
Well,
happen.
and for anybody who knows, like, have you seen those commercials where go to this website, search your name, and see if you have any assets out there?
Yeah.
Well, that's what we're talking about. Those assets are being held by a state.
Yeah.
Right. It was escheated to a state. So if you have like a client had a 401k that had like $2,000 on it, right? And they lost track of it, they forgot about it, whatever. And then they put their name into the system and they're like, oh, I've got $2,000 sitting out there, right? It has zero growth, by the way.
I was owed $40 from Verizon from 10 years ago in Montana.
There you go.
I got a check for $40 from the state of Montana.
And people seriously need to, if you just need to check those if you've never done it, just because you never know. What if there is something that you completely missed for some reason? And any state you've lived in.
Yep. Person or organization. My church had some too.
Oh.
Yep.
Nice.
Because we had accounts in our name.
Yeah, that's good.
very
Good to know. Yep.
So I don't believe Prince had children.
You're right. Yeah. So Prince didn't have children. He had
Who
an
knew
estate.
Prince trivia was going to do so good for me today?
I know.
I'm so
You
excited.
were on top of
Impressed.
this.
Do you know how many heirs there were?
Oh, I don't.
Well,
Well, so
I'll get
Does
there.
anybody?
how many children did he have? And
No. He didn't. So
he
no
didn't have
children. No
No
children.
children.
He wasn't married. His estate was worth about 150 million.
150 million.
Yeah, and you asked a question about tax planning strategies, and when the estate goes through probate, obviously the IRS gets involved as well. And so initially, the heirs were trying to say the value of the estate was somewhere in
Much
the range
smaller.
of 80 million.
Yes.
And the IRS contested that. So it came out closer to 163 was what the IRS valuation was, but the heirs were saying 82 million. The taxes are significant now. The taxes for a taxable estate, it's 40%. So you're talking about a significant chunk of the estate that's going to be taken if you're in that taxable estate range, which is anything above 13.9 million. So it's not everybody who falls into that range, but it's still significant.
Right. Because my guess is some of the valuation was because it's non-monetary valuation. It's like the rights to the music and all that kind of stuff, and it's like almost not quite a matter of opinion. But
Right.
I mean, it's you have to, or if it's like land, like how much is the land worth? Well, I think it's worth $10. You think it's worth $1 million?
Yeah.
Right. And when it comes to tax man, I think it's worth $10.
Yeah,
Right.
exactly.
Yeah. Okay. So that's why there
Exactly
can be a difference. It's not like they're looking at bank account balances.
Right.
or anything like that. It's
you have
like,
to put an assumed value on it. At
yeah,
that
you got to put an
point in
assumed
time.
value. And they're like, and at that point, yeah, nobody was listening to Prince music at that time. It wasn't worth that much. I'm sure it was an argument. So how many heirs were there? You left us hanging.
Oh yeah. So while this trial was going on, while the proceedings were going on, 45 people came forward saying that they were heirs to the Prince estate. Wow. It ended up being 6 people who ended up receiving from Prince's estate, and those were siblings, mostly half siblings. I think he had 1 full sibling and 5 half siblings, but it was 6 siblings who ended up receiving his estate, and that speaks to the idea. It went up and then it went back out, and then it ended up going to half siblings, which, you know, in a lot of cases, you could imagine that somebody may or may not have a strong relationship with their half siblings. I mean, there's some people who would say, yeah, of course I'd provide for my siblings. Maybe, of course, I'd provide for my half siblings, but you can also imagine situations where people think it's either going to go here or it's going to go here.
And you have to make an argument there. And it wouldn't, I mean, was it shared equally amongst the 6 siblings?
Yeah, ultimately it was just divided among them. Yeah.
Okay.
But other people had come forward, right? I mean, if you know, Colorado's a good example where you have the accidental marriage situation where people will come forward and say that they were married to a decedent, because in Colorado you don't need a marriage license in order to
Common law.
If common law marriage.
We lived together for 3 years, and that's
Even if we say we're
whatever,
married,
We held ourselves out as married.
yeah, that's it. We held ourselves out as being married. So a lot of times what happens is somebody dies with a boyfriend or a girlfriend. The survivor finds out, wow, they had a lot of wealth, and they say, we weren't boyfriend and girlfriend, we were husband and wife.
Look, we checked into this hotel under Mr. and Mrs. Smith one time.
Exactly right. And that's the type of evidence that could be used. Yeah. So even in an obituary, sometimes someone will affectionately refer to a deceased person's partner as their spouse or their wife, and that could be used as evidence in court to say they were married because they held themselves out as being married.
And if reasonable people think you were married,
Yeah.
you're married.
Yeah, exactly.
It is sometimes interesting in legal proceedings how much stuff comes down to a matter of opinion.
Oh yeah, and in
Based
this
on
case,
That's all it is.
no, of course, this is not even. There's no elements for marriage in Colorado. It's a totality of the circumstances. So you know, if you commit a crime, usually there's an elemental test.
Right.
Did you do this? Did you do this? Did you do this? If that can be proven, you committed the crime. In Colorado, when it comes to marriage, there's no list. It's just the evidence that you could compile. So if you find a video footage of the two of them together, and the deceased husband's giving a toast, and he says, "I'm happy to be here with my wife," that's something that could be submitted to the court as part of the totality of the circumstances consideration.
No, I totally buy it. I totally do. I actually had a case once in my church back in Ohio. I had 2. One involved marriage. So somebody needed to prove that they were married, but it happened like they were both in their 90s and they got married in their 20s, and there was no record. Like the courthouse had burned down, right, and everything like that, and they had to prove it. And I had to go through the old church ledger book and take a picture of like the ledger book where somebody had handwritten in Mr. and Mrs. whatever, we did the marriage on this date.
Sure.
And they accepted it. They're like, okay, that's as good as you're going to get. And they're like, okay, then you're married and this is the date you were married on.
That's interesting.
Yeah. And then I had another one guy trying to prove that he when he was born, because he was, again, like 95 years old. There were no records, no birth certificates, no nothing. It's long since done gone. And so we had to find his baptism record that happened to also have his birth date on it. And that became the official record of his birthday because it came from a church. They're like, oh, yeah, we'll take that.
Yeah.
Crazy.
No, it is crazy. And you can imagine when you have elderly people and you have an elderly man or an elderly woman saying, this was my wife or this was my husband, it's very difficult as the young heirs to come in and argue against them. That's a very sympathetic character. So
that's it. Okay. I have not had this, but I know people in my profession have had it where they've had people come and they say, hey, we want to have a wedding, but we're not going to sign any papers because we don't want to be actually legally married.
Yep.
But the reality is if they come forward and have a wedding and
in Colorado.
I've heard it in Colorado. They're like, sign the papers or don't.
Doesn't matter.
You're probably going to be legally considered married. If you have a wedding and, invite everybody and say, congratulations, Mr. and Mrs. Smith.
No, of course. I mean, that's usually one of the criteria, right? If they had a ceremony. So Prince had people come forward. It's not clear why everyone came forward. 45 people is obviously a lot.
$161 million is why they came forward.
Exactly right?
Yep.
So their basis for coming forward might have not been clear, but you could imagine people said, Prince had promised me X, he had promised me Y, we were together, he had written this down, he had said this, he had said that. So taking your stab at winning the lotto, I guess, is what people were doing. But
so then 163 million, I think is what you said, right?
well, the IRS said, right?
The IRS said, okay. So then he did no planning, so there's no tax planning.
No tax planning at all.
So at the end of the day, how much money was left for the heirs?
Well, it would have been a big chunk. I mean, we're dealing with 2016 numbers. So if we use today's numbers, though, Prince is one person, so he could only pass today 13.9 million, and now we have significantly more that we could pass than we could, whatever, even 3-4 years ago. So this was 9 years ago, but you're talking about what 147 million that would be subject to taxes today at 40%. So I mean, it's almost half of the estate that's going away. You're talking about a pretty small portion of the estate that's actually getting passed to the heirs.
Yeah.
And it's interesting because you had brought up the idea that we're not talking about bank accounts. We're talking about things like rights to music, and so there's a lot of planning that can be done. And this might not be applicable, to most of your listeners. Maybe most of your listeners are not musical artists, but a lot of your listeners might have assets that are valuable, but it's not actually clear what the value of those assets are. And if you plan ahead, you can figure out ways strategically to either value those assets appropriately so that you're able to pass them in a more efficient way, or you can actually reduce the value of your own assets by planning intelligently. Like, for example, you can break up who owns which portion of the asset.
Okay.
Like if we own an expensive house together, and we own 50% each, my 50% interest in the house is not worth half the value of the house. It's worth less because who am I going to sell it to, right? If we have $1 million house.
Oh, yeah. Because nobody's going to be in the market to buy half a house and they have to live with me.
Right. So I can reduce it, right? I could say, look, I don't control the whole house. I can take a discount. And the IRS allows for that sort of thing. And so there's strategies that you can use in order to get discounts and take advantage of maybe the lack of control that you can actually create in your own assets. So.
Right. Well, and I'm sure at the end of the day it worked out. Everybody came out on the winning end at least a little bit on the heir side. But I was sitting here thinking like, oh wait, like it's not like for the heirs who then like have a bill to pay. It's not like the IRS are going to accept. You can have the rights to Purple Rain as a means of paying my taxes, right? They want cash,
right?
Cold hard.
So now you have to you're probably liquidating.
100%. Yeah, you're
some of the
liquidating
stuff in
assets.
order
And you're
to pay the taxes.
liquidating it not full value, probably.
Right, because they know you got to sell. You're an eager seller at that point. Which for a house or something like that, that's one thing. There's a housing market and everything else. But like this kind of specialty stuff, like who's going to come buy it? Warner Brothers going to come buy it back, and they're going to give you 10 cents on the dollar.
Right, and they can, right, because the IRS is going to want its money. So. Yeah. Especially if they've valued it at double what you believe it's worth. I mean, you're going to have to sell it at a pretty significant discount at that point.
Yeah. Oh my gosh. Okay. All right. Prince, do better. Oh wait, never mind.
Way to go.
I'm doing better than Prince right now.
Is this little pastor's humor right here?
Oh, we have all kinds of.
All right. Who's up next?
All right. So we're going to stay with musical artists, and we're going to go to Aretha Franklin.
Aretha Franklin.
Do you have any
Well known
facts about Aretha?
I don't. I didn't see the movie. I meant to. I heard it was really good.
She's we go from Prince to the Queen, right?
Right.
The Queen of Soul.
Oh, yeah.
So
there you go.
That's my string tying everything together. But Aretha Franklin, she's a blend. She's a blend between Kobe and Prince. She didn't not plan, but she didn't exactly plan appropriately. As a matter of fact, when she passed away, her will, at least one of her wills, was found in between some couch cushions.
Oh.
Yeah, so she had created a will in 2010. Then she had created another will in 2014. Both of the wills she created herself. They're what's called, they're handwritten, which we refer to that as a holographic will. If you handwrite your will, it's considered a holographic will. And the wills were different in that they provided for different children in different ways. They provided for different terms for the children's inheritance. And obviously, as a result, a battle ensued. So she had she had kids. She had 4 kids, and all boys. And in one will, her main house was divided between 2 of her boys. In another will, that main house was just going to one of the boys. So, so they had to go to court.
And what was the size of the estate?
Her estate, I mean, the value was kind of unclear because it was a lot of property, but the biggest thing that came out of it was the conflict between real estate, because she had owned a few, I think she had owned 4 big pieces of property, and that's really what was battled over by the boys, because she had designated specifically where those would go.
So that ended up in court in front of a judge.
In court, yeah, and it was in court for a while, but plus, the legal fees and everything else involved in that. Process.
Your lawyers got to get your piece.
Exactly right. So
hey, nobody works for free, people.
A lot of DIY estate planning, and we saw how that planned out. But then we also saw even something as simple as document storage. Where you leave your estate plan is almost as important as if you've created an estate plan.
So is it more reputable or less reputable if you leave it in the couch?
In the couch cushions, yeah. We say not a good place to store your estate plan.
I would think it'd be great. Prominent place they hang out, important documents.
Somebody's got to find it. Yeah.
No, exactly.
Somebody's going to be looking for the change. They'll find that will.
Yeah.
Yeah, so document storage, I think that's right. Aretha Franklin wasn't somebody who didn't have the capacity to leave things at least in a safe place, or at least let somebody know. Instead of leaving it in the couch cushion, she could have left it there and let her kids know, by the way, I store my will in the couch cushion. But she didn't do either of those things. So when probate was initiated, they had the 2010 will, and then the 2014 will was later discovered. There was a conflict between them, and the court had to figure out which will would be used to probate the estate.
Wow.
So how, when would a court throw out a handwritten document and just go by state law, or would they?
Well, they would do what they could to try and show, that the written document actually expressed the intentions of the decedent. But, if the decedent might have been compromised at that time, they weren't mentally able to make those sorts of decisions. They didn't understand what it was that they were doing. Maybe it's not clear that this was even the decedent's handwriting.
Well, and that's what I mean, because when I see people execute wills, they're signing their name, and there's a notary and there's witnesses.
Yeah.
Right? So if none of that exists, how can the court assume it's legit?
Well, the handwritten will, that's something that still can take the place of a notary and take the place of witnesses if it's in your handwriting.
Okay.
So so that's one of the considerations.
You'll know if it's in my handwriting.
No, exactly, right? If you write something out. That's
if it's legible, I didn't write it.
We won't know what your will says.
No, I know.
That's the old saying, right? You could save money on your legal expenses. You could do your will on a napkin, right? The problem is it going to cover what you want it to cover, and is it going to do it appropriately? So you could do it. You could still do it. It's not advisable.
Okay. And like we saw with Kobe, you probably will miss something.
So
exactly.
So far I've learned, plan something. Don't just not plan. Keep your plan updated, and don't store it in the couch cushions.
Don't store it in the couch
cushions. Or if you
cushions,
do, you just have to make it known.
Make it known.
I hold my will in my couch cushions.
There you go.
Oh, yeah.
That's where I'm doing
in fairness, like my former mother-in-law, she showed me, she's like, this is where I keep my stuff. And so that's where I know to go get her stuff. And so, yeah.
Yeah, no, some...
it was not the couch cushion, but...
yeah, don't put that out on the air.
No, I'm not saying where. It's actually kind of clever, but I'm not going to say where. So.
Yeah, but if you're going to hide things, even if you put something in a safe, right? That comes up also. I'm sure you've dealt with that, where somebody puts something in a safe, but nobody knows the combination to get into the safe. Oh. That's problematic. Put it into a safety deposit or security deposit box,
which is actually a real problem.
That's
actually a major problem.
It's a major problem because it's hard to get into these deposit boxes.
We've talked about this on air actually.
Yeah.
And the situation is, if you die and you have a safety deposit box, right? Who can get into that safety deposit box?
Not many people.
Right. But you have to get through the legal process to do it.
Right.
And all the legal documents are in the box that you can't get to. It's a problem. You don't hold those assets or those documents in the safety deposit.
Yeah. So
All right,
it's
you
just-
got one more for us?
I'm actually really curious before we move on.
Yeah.
So, if for your guys' firm, Budman Law, like when you execute an estate for somebody, an estate plan, I should say, excuse me.
Sure.
What do you guys do? Because everybody signs stuff. Do you guys actually keep a copy of it? Is it on the client that you're serving to keep the copy? Like, how does that actually work? And what if their house burns down and their documents were in it? Is their estate plan gone?
No, yeah. So we dealt with that, right? In Colorado, we had fires in Colorado, and we had some clients who were affected by that. As you can imagine, when people leave their home, they don't think, let's grab the estate plan.
Right.
So we had estate plans that were left behind. We take copies of everything. So clients receive hard copies, and we take digital copies, and that's what we maintain, and that's sufficient. I mean, if there's a situation with an estate, somebody passes away, and the only copy that can be retrieved is a digital copy, that'll still serve to administer the estate effectively. Now, the going advice would obviously be, let's re-execute documents. Let's make sure that we have hard copies in place.
Right.
And also, of course, in situations like that, the assets and the estate usually change anyway. So people are having that conversation. Yeah. But when documents are misplaced, we still maintain that. And a lot of attorneys used to, I think it's a less common practice now, but they used to actually maintain the hard copies for all of their clients. So attorneys would have, like old school estate planning attorneys will have storage units, multiple storage units, where they'll store all of the documents that they've ever created, so that when a client does go through probate, they're able to actually go into their files and lodge that will with the court.
Very interesting.
So my sister, who doesn't have any kids, like I'm her executor, but I have a copy of her doc. She's got a copy at her house, but
Sure.
I also have a copy of her stuff at my house.
Yep.
And vice versa.
Yeah, no, and it's a good practice, right?
Yeah.
But let's say your sister updates her plan. She should let you know, because otherwise we have another document circulating out there.
Yeah.
And that's, like Aretha Franklin, her situation, it's not uncommon, right? A lot of people will set up their estate, and then later in their lives, like one of the provisions in Aretha Franklin's 2010 will was that if her kids wanted to inherit her estate, they would all have to get a business degree before they could receive her estate. She was concerned about their ability to manage the assets. And she ended up taking that provision out in her 2014 will, which I'm sure the kids appreciated, but also she might have figured that my kids are more mature now. I'm not as paranoid about their ability to manage assets. We obviously don't know. But these sorts of things happen. Like a kid at one point is young enough to where you think we need parameters in place, and then they're old enough to where we think, okay, they're fine. They can handle things. But if you have two documents out there just circulating, then when you pass away, how do you know which one to interpret? And it is the case that sometimes people will say, well, this is actually what mom wanted. This is actually what dad wanted, because maybe that will or that estate plan is more favorable to the heir.
Wow.
So it's important. I mean, you update, but you have to let people know, hey, I've updated things, just so you know. So the old document that you have, destroy it, because we don't want a conflict to arise.
Right.
Well, and then if you do it properly and you have it notarized and witnessed,
Yep.
there's less argument to be made on the old document versus the new document, correct?
Yeah, that's a great point. Yeah, of course. If you do it properly, if you're not just handwriting documents, you do it properly, you have a signed and notarized version, and it's dated more recently, there's less of an argument. But if you're dealing with copies, if there's confusion, if at the end of life people were worried about the decedent being taken advantage of, then questions arise. And so then even the unintended consequence is that people are going to go to court, because, especially if you disinherit people, right? If you change your plan and it's to the disadvantage of an heir, well, the old plan usually it resurfaces, right? Because people think I'm losing my cut, so I might as well, throw my hat in the ring and try and resuscitate that.
There you go.
Very
All right.
interesting.
Do you have one more?
I have one more if we have the time.
I think we got just enough time.
We do.
All right, perfect. So this is a brief one, and I'll be brief with it, but this is a good ending point, because it kind of balances a lot of what we've discussed, where somebody had a plan in place, they did plan appropriately, they thought of most everything, but there was a blended family situation. So we're gonna go through Robin Williams. He's the last one, and he, as you know, actor, comedian, Good Will Hunting.
Good Will Hunting.
How do you like them apples?
Mrs. Doubtfire.
Mrs. Doubtfire.
That's the best one, I think.
Mrs. Doubtfire's good.
Dead Poets Society.
Dead
Oh, that
Poets.
was a good one,
Ooh,
too.
I don't know. Dead
That's a good one,
Poets. That was a
too.
big deal in my life. Okay.
So I had a good fact about him actually that I wanted to share because I thought it was a nice fact. But apparently, what Robin Williams had done was he set up scholarship funds at the Juilliard School of Arts, and he did it in the name of classmates who he knew were not able to pay their tuition. And so he set it up in their name, and he did it all anonymously, and that came out after, posthumously. But Williams died in 2014, and he did have his estate in place, but he was on his third marriage, and his children were not with his wife at the time of his passing. So things were handled generally, but a dispute arose as to Williams' memorabilia. That was the dispute, the big dispute. What constituted household contents and what constituted personal effects? And the children obviously had a sentimental feeling towards some of the memorabilia. And of course, there's value, in a lot of our cases, when we talk about memorabilia, it's strictly sentimental. But in William's case, there's also a significant
'Cause
value
he was so
associated.
famous.
Yeah.
Yeah, so there had to be, this had to go to court, right? There had to be some sort of resolution as to where this property would go. Because just because it was in his house, did that mean that it constituted a household item? Or was it separate memorabilia that should be distributed elsewhere?
Oh, well, I could see this even you didn't say it, but like in the Kobe case, right? Like maybe Kobe's got the basketball he won, whatever with
MVP trophies.
So MVP trophies,
What are
like
they
is that
That's
household
true.
content? Because that man on eBay, that would do good.
But think about in Kobe's case, the woman to whom he was married when he passed was the mother of his children.
Right.
So we
Less
see
argument.
Yeah, we see less argument. So when you deal with somebody who's in a traditional family structure and it's husband, wife, and they have kids together and that's it.
Oh, right. Like she wasn't even around when Mork and Mindy was filmed, and this thing happened
Exactly.
that she's trying to.
Yeah,
Okay.
and there's less of a concern because people think, oftentimes, well, dad's not going to get rid of the stuff that mom had that meant a lot to us, or
Right.
vice, whatever. Mom's not going to get rid of the stuff that dad had that meant a lot to us. But when you're talking about a second marriage, or in this case, a third marriage, sometimes the wife, as good of a person as she may be, she's disconnected from the children. So maybe she feels like, well, this memorabilia is going to help sustain my lifestyle, and she wants to make sure that she can afford the things that she had prior to the passing.
Right.
And so this battle arose, and the big takeaway from here is really it's similar to Kobe, right? We have to be thoughtful in the way that we plan. In Kobe's case, it seems like it might have been a case of maybe the attorney's not thinking through what could happen. But in Robin's case, this comes up. This comes up regularly. When we craft an estate plan, we include everything that somebody owns in their estate, right? But we don't necessarily designate where that's going to go. And when you don't designate that appropriately, what happens? And in Robin Williams' case, a very simple solution to something like this would be like a lottery drawing or a draft for Robin Williams' stuff among his heirs. So if he said, look, this is how I'm going to set it up. I'm not going to necessarily designate, because I'm sure he had a lot of memorabilia. I'm not going to designate this goes here, this goes to my wife, this goes to my son, this goes to my daughter. But instead, I'm just going to say, I have memorabilia, anything that's not furniture in the home, any decorations, anything that I own. My wife and my children at the time will sit down, and in this order, they'll each be able to pick something, and they'll go through until every item's selected. And that's an easy solution because that doesn't go to court, right? It doesn't go to court.
But this is real for other people. Like for instance, someone has a jewelry collection,
Right.
Right. Who does it go to, right? Or a gun collection. Like these are real things that normal people deal with.
Yeah. Right.
And if you don't name it, it's really argued over, right? Now, are those people going to take it to court because it's not probably the same amount of money? Probably not.
No,
but it's still a problem, and
but-
you could create clarity in your plan.
Yeah,
Sure.
I like the lottery idea. I think there's a really famous case around this, but it had to do with divorce, and it was a couple divorcing, and they're trying to divvy up who got what Beanie Baby, And I was watching the BB Manny documentary, which is fascinating, by the way. You should watch it. And they had footage of this, and literally the judge is like, "All right, you flipped a coin, like you start," and then they just picked one at a time, trying to figure out like, who got one, so because they couldn't decide. But the lottery system, I'm like, oh, that's like an actual thing. I thought that guy was just really clever.
No, it's a provision that you could put into a plan. I mean, you could actually write, "My trustee shall flip a coin, and depending on whether it lands heads or tails, this is who will select first," and they'll go back and forth until they've selected everything they want.
That makes sense. I think Roy's point's right on it, because if you're a collector of something, you know, and I think like around here, guns is a good one, and or jewelry or whatever, you could have some valuable pieces that are both financially valuable or sentimentally valuable.
Yeah.
And then it's up to the heirs to decide which they care more about. Do I grab the expensive one or the one that means something to me?
Of course. You don't always know, right?
But that's on them.
Of course.
Yeah.
But at least what you can do is you can plan for a structure so that this doesn't result in a court battle. Right? I mean, that's the benefit. Everyone could be kind of bothered with you, but they're not going to be bothered with each other.
Right. And I've actually heard of situations where, you have a remarriage, or, the first spouse passes, and the husband of the deceased spouse will want to keep stuff that was theirs, right? That they had together. But the children also have sentimental value to that, right? Yeah. But they're not going to take it from their dad or ask their dad for it while he's alive, right? But if he remarries and then passes later, and the kids now are like, well, yeah, we'd like this stuff now. But the new spouse is like, no, this is our stuff, so we're keeping that, right?
No, it's a great example.
That creates a very messy situation that unfortunately needs to be thought through, so that in a blended family situation like that, the children could have something of their mother who's been long gone, right?
Right.
That now that they lost their father, they don't even get anything,
right,
in remembrance of their mother, kind of situation. Wow. So that's a real scenario that I've actually run across, and it's a real mess actually for that family.
Yeah, and it's difficult to deal with because it's not about the cash value.
No, right? It's all sentimental.
It's all sentimental, yeah. Right. So it's,
another fun fact about Robin Williams, by the way, he was so giving because he actually took care of Christopher Reeve's family.
Yeah.
As I understand it, Christopher Reeves had run out of money, and from after spending on his own care of it, he basically took care of him.
No kidding.
Yeah.
That's fair.
And again, I mean, Christopher knew, but nobody else knew until after Robin passed away.
Yeah. Well, that's part of that whole thing, right? Like when you die, a lot of the privacy and everything kind of comes out. My favorite story about
good
that,
or bad, right?
Yeah, good or bad. My favorite one was when they found out that when the guy who founded Little Caesars passed away. Only after he passed away did they find out that he had been paying Rosa Parks' rent for like her entire life.
Wow.
Because she was famous, but you don't make money just being famous. And he was such a big believer
social media back then,
right? She couldn't become a social media influencer like that. So it turns out she lived in Detroit, and he lived in Detroit, and he paid her rent for decades, and I think he cared for that in his will, but nobody knew he did it until then, because he didn't want until he had passed.
No, it's true. I mean, dead people don't have any rights, so people should be aware of that.
Well, this pop culture adventure has been kind of fun, man. Maybe we need to do this a little more often for different things. But let's kind of wrap up here, because this has been fun and everything. But fundamentally, if people are out there and they don't have a estate plan right now, like what do they need to do? Like you should have these things basically. If nothing else, have at least this.
Yeah, no, I think that's a good starting point, right, for a lot of people, and I think this is something that my father actually mentioned when he was on the podcast as well. But basic incapacity planning is a huge thing. I mean, the one thing that isn't covered, right? I said earlier in this episode that if you don't have an estate plan, the good news is that the government's created an estate plan for you, right? I mean, good news, bad news, whatever. But we talked about your estate could go to your wife, it could go to your kids. Maybe in your situation, there's not going to be a hitch. But if, God forbid, you become incapacitated, there is not a plan in place for you. It's not as though the state says, well, you'd probably want your wife helping you out. I mean, that would make sense, but that's not the case.
Okay.
So incapacity planning, basic powers of attorney, that's a great starting point. And then this is probably sacrilegious for me to say as an estate planning attorney, but at the very least, making sure that you have beneficiary designations on your accounts. I mean, that could save you a huge headache, save your heirs a huge headache, because what you're doing is you're taking care of estate planning essentially on your own. I generally don't recommend that people go and draft their own documents, because I think that As they read through them, they'll likely feel like they want to adjust those documents to make them fit better with their wishes. And there's unintended consequences of doing that. But if you go to the bank or you go to your financial advisor, you speak with your insurance agent, your life insurance agent, and you say, this is who I want to provide for. And if God forbid anything happens to me, this is where I want the account to go. Then you can at least put yourself in a position where you can be better oriented towards transitioning your estate to the people who you love. But incapacity planning is a big one because there's no solution for that. No beneficiary designations. Your estate will go to your family. No incapacity plan. It's in limbo. Who's going to be able to provide for your care?
Well, and it's the worst because somebody who loves you will step up, right? Mm-hmm. But now they have to go get the legal authority from a court.
Right. Of course.
And not only are they dealing with you being ill for whatever is going on, now they have to go to a court and get approval. And oh man, what a disaster. So you do that planning for someone you love.
Right. Yeah.
Because
and think
you don't
about
want them to
this.
jump through those hoops.
When you talk about the public process, right? Part of incapacity, at least getting a guardianship or a conservatorship over somebody, is demonstrating to the court, which means demonstrating publicly that this individual is so incapacitated that I need to be given the authority to step in on their behalf. So that's, you're publicly showing it. And so for a lot of people, it's for anyone, it's an embarrassing process. Most people don't want to be put in a position where, they were once whatever it was in their community, and now they're being propped up so somebody could show, look how incapacitated this person is. So
that's rough.
That's rough.
So so there's some really good tips right there because you can at least do that very inexpensively.
Yeah.
And if you have other needs, you definitely meet with an attorney to get legal documents drafted properly.
And and if you really are interested, we covered a lot of the technical ground in our estate planning with Skyler's dad, which was great. Though I have to say, I think yours was more fun.
Yeah, I get that a lot.
Yeah.
I mean, he's kind of he's the expert, but I keep it lively.
Yeah, I gotta say, they make good bookends. They make it good. So good.
A yin and a yang.
Well, Skyler Budman of Budman Law, it is really great to welcome you to the About Podcast. This has been wonderful. Thank you for joining us.
Yeah, thanks for having me.
We really appreciate it. And thanks, everybody.
Yeah, thanks, everybody. Don't forget, subscribe, share with your friends, people who need estate planning, or just like celebrity gossip in this particular episode. That all really helps us out.
CWA is a Securities and Exchange Registered Investment Advisor. No content contained herein should be construed as an offer for investment advice or an offer for the purchase or sale of any security, insurance, or other investment product. Investments involve the risk of low loss, including loss of principal. Please consult with a qualified financial, tax, or legal professional before implementing any strategy presented here. Data presented here are obtained from believed reliable sources but cannot be guaranteed as to completeness or accuracy.